Hello friends, my name is Tejpal and today I am going to discuss with you the solution for a paper of a company law of a CS executive program, a June 17 examination conducted by the ICSI. The paper of a company law was completely based upon the practical questions. Hardly I have found the theoretical question, and therefore the student are required to be good in an application of the provision. Let us discuss the paper. A better would be you are having the paper in your hand so that you can read the question, because I am going to discuss only the answer. Question number 1, it is a question demanding the comment, and each question is of 5 marks each. Question number 1A, a limited liability partnership LLP can become the member in a company incorporated under the provision of the Companies Act 2013. Remember, any natural person who is capable to enter into the contract, or any artificial person having a separate legal entity can become the member in a company, and therefore the LLP, limited liability partnership, can become the member in the company. It was a very easy question in my opinion, and to start with the easy question is the fantastic idea. It will give the soothing effect to the students at that time while they were writing the paper. Question number 1B, the consolidation of the financial statements is a mandatory for all the companies, including the unlimited companies and the private company. Yes, statement is correct. The consolidation is a compulsory for any kind of a company if it is having either a subsidiary company or a joint venture company or an associate company. You may refer the paragraph number 3 of chapter number 21 of my book for a detailed answer. And moving the question number 1C, a statutory auditor of a private limited company is restricted to take up the other assignment in the companies. The question is based upon the number of audit the one auditor can undertake, and there are some guidelines issued by the ICAI which also provide the number of audit the auditor can undertake, right? So the auditor can undertake only limited number of audit. A private company is included or not included depend upon the criteria, because the ICAI has provided the criteria with regard to the capital, etc. But the one thing is assured that the statutory auditor cannot provide the other services. It is restricted under the Companies Act 2013. So it was a good question in my opinion, 1C. Question number 1D, a merger of a subsidiary company into the holding company. Remember, now the provision of amalgamation and merger are available under the new act, the new Companies Act 2013, and there is called a fast track merger, but the fast track merger is possible only between the holding company and its 100% subsidiary company. Now the question is not clarifying that whether it is a 100% subsidiary or not. So if it is a 100% subsidiary, then the company or companies, they may go for a fast track amalgamation or merger. Otherwise, they will have to follow the routine or a regular process of the amalgamation or merger. Question number 1 is over here. Going or moving towards the question number 2. Question number 2 is having an option 2 small a and 2 capital A. a student may attempt any one of it or any one of them, 2A or 2 capital A. Now 2A, one, that is the distinguish between the e-voting and the voting by way of a show of hands. In my opinion, that this question of a distinguish, all the questions on a distinguish are prepared by the examiner after the careful thinking, and those who are or who have read the small booklet kind of a material, or only the few past examination papers, they won't be able to answer it in a proper manner. Only those students who are having a concept clarity can answer it in a thorough manner, answer it in a perfect manner. E-voting is applicable to the certain companies and certain categories of the company. While show of a hand, this method is applicable by almost all the companies in their meeting. But e-voting is more suitable when the number of participants are large, while voting on a show of hand is more appropriate when the participants are very less, countable. So we can say that the e-voting is the modern method which has only been introduced by the Companies Act 2013. Earlier than that, it was not available, it was not allowed, while show of a hand is a traditional method, old method. In e-voting, the notice convening the meeting should specifically mention that the voting will be conducted by the e-voting facility will be available, and member may avail this e-voting facility by this mean. On the other hand, voting by way of a show of a hand is a regular method. So the notice of the meeting is not required to specifically provide that the voting will be conducted or exercised by the show of a hand. One another point of a distinction I would like to share it with you is that e-voting is something where the person will get the voting in a proportionate to their holding. Say for example, I am having 100 equity, I will get a proportionate number of votes. On the other hand, if it is a voting by a show of hand, irrespective of my shares, I will get only the one vote because I can raise only the one hand. If I raise a two hand, it will be a surrender. And in e-voting, you don't require to attend the meeting because e-voting will be over the one day before the scheduled time of a meeting. While in the case of a voting by way of a show of a hand, the voting will take place at the meeting and there is a requirement of attending the meeting, right? Moving the point number 2, and that is another distinguish between the key managerial personnel and the managing director. Again, I am very much impressed with the examiner because he has found out the good differences. You may read this difference in my book in a paragraph number 1, chapter number 17. However, I would like to tell you the one main point of a difference between the KMP and the managing director, that every MD is not the KMP. The MD is KMP only if he has been appointed as a KMP, and the appointment will take place by passing the board resolution, right? On the other hand, the CEO, CFO, CS, now these people can also be appointed as a KMP. So the KMP and the MD are different. MD has been considered as the person who is having a substantial power of the management of the affair of the company, while on the other hand the KMP is the key managerial personnel. The person who is appointed as a MD still can be appointed as a MD in another one company by passing the resolutions, etc., or by complying with the other formalities. If the person is a full-time KMP in a one company, usually he cannot be appointed as a full-time KMP in another company, right? Except he can be appointed where the government has allowed, right? Or in a subsidiary companies or for the purpose of group companies, etc., right? Question number 2C, that is again a distinguish between the internal audit and the secretarial audit. Remember, the internal audit is based upon the provision of section 138, while the secretarial audit, the provision is contained under section 204 of the Companies Act. You may appoint any person as an internal auditor, either a practicing chartered accountant, company secretary, cost and work accounts, any other professional if the board considered a think and fit. But you can only appoint the practicing CS as a secretarial audit or auditor. Employee can be an internal auditor, but the employee cannot be a secretarial auditor. Usually the private company, if it attract any of one of the threshold, like a turnover, like the profit, or like the borrowing or outstanding borrowing, it is required to appoint the internal auditor. But the private company is exempted from the provision of the secretarial audit. And there is no specific reporting requirement or reporting format made for the purpose of an internal auditor. No doubt the internal auditor is required to report to the audit committee and to the board of directors. But secretarial auditor is required to submit his report in a form number MR3, right? So it is a point of differences between these two. Moving the point number 4, that is a question number 2, small d. Distinguish between the punishment for a false statement and punishment for a false evidence. You may refer the para number 5 of chapter number 31 of my book. It is a very small point and only the difference is in the penalty amount or a penalty prescribed under the Act. So in my opinion, the question number 2, small a, small b, small c, small d, all containing the differences, are very good questions, very interesting question, where I am of the opinion that the student must have felt the difficulty. Moving to question number 2, capital A. And question number 2, capital A, question number 1 in that, Sun Industries Private Limited Company has its paid up share capital of 40 lakh rupees and turnover of rupees 10 crore as per their last balance sheet. Examine the provision of a Companies Act 2013 and decide whether the company will be a small company. And what would be your answer in the case a company is governed by the special act? Yes, it is a small company based upon the turnover and the paid up capital. But the answer would be a different if it is governed by the special act, right? You may refer the paragraph number 5 of chapter number 2 of my book, A Company Law, 3rd edition by the Taxman, which is meant for a December 17 examination and which is published in a June 17. Question number 2A, number 2, A to Z Management Services Limited is a listed company quoted at the Bombay Stock Exchange. The company closed its register of a debenture holder in June and August 2016 for a 12 and the 21 days respectively. The Chief Financial Officer of the company has informed the Secretary of the company to consider the closing of a register in December for another 15 days for some strategic reason. Remember, we are not concerned with the strategic reason. Referring the provision of the Companies Act 2013, examine the validity of the above action of the company. The question is testing your knowledge with respect to the section number 91. Section number 91 says about the closure of the register of members and the register of debenture holders, etc., it says that it can be closed down by the company after giving a 7 days advance notice. If it is a listed company, the advertisement or this notification should be published in two newspapers, one in an English newspaper, another in a regional newspaper, right? Now here in the question, it has been closed down twice, once in a June and second is August. Now they would like to do it a third time somewhere in the December. So in the span of 1 year, they would like to close it a third time. See, the section 91 do not provide any frequency. It says that in a 1 year, the register of members and the debenture holders should not be closed down for a period more than 45 days. And at a one time, it should not be more than 30 days. So it is not more than 30 days in a one time. Total 45 days, we will have to check it. So 21 and 12, so 33. So further 12 days, they may go for the purpose of a closing of a register of members after complying the formality. If it is a listed company, in addition to the Companies Act 2013, the listed company shall also comply the SEBI LODR provision. So it was a good question. Question number 2A3. Mr. Atul Rastogi, the managing director of ABC Limited, has resigned from the managing directorship of a company. He, however, wants to continue as a director in the company. Referring the provision of the Companies Act 2013, state whether Mr. Atul can continue as a director in the company. Of course, he can continue as a director in spite of the fact that he has resigned from the office of the managing director. Why? Because the position of a director and the position of a MD is a separate. He cannot continue as the MD after resigning from the director, but he definitely can continue as a director even though he has resigned from the position of a MD, right? You may refer the paragraph number 1 of chapter 17 of my book, 3rd edition, A Company Law by the Taxman, for a December 17 examination. Question number 2A4. Innovating Engineers Limited has 2,505 members as on the date of a company's EOGM. The Executive Director, Mr. Avinash, has asked you, the Secretary of the company, what is the required quorum for the meeting. Referring to the provision of the Companies Act 2013, inform the Executive Director, Mr. Avinash, the quorum that must be present for the holding the EOGM of the company. Remember, the slab for the purpose of a quorum is given for the purpose of a public company. And when the total number of members are between 1,000 to 5,000, the quorum shall be the 15 members personally present at the meeting. So it is a very easy question in my opinion, but only or provided you have remembered the threshold or a limit. Again, one more question is there in the same question. State whether the required quorum must be present throughout the meeting. Now, if you refer the provision of a meeting, a quorum, etc., nowhere it has been specifically said that the quorum for a general meeting should be present throughout the meeting. But if you refer the Secretary Standard 2, the SS2 specifically provide that the quorum shall be present throughout the meeting. Moving to question number 3, 3A, XYZ Limited has office holding in London. The company has been granted a term loan of rupees 15 crore from a bank. The company wants to mortgage an office building of London. Examine the provision of a Companies Act 2013. Answer the following. Number 1. Whether the company can mortgage the above office building. Yes, the company can mortgage any office building where it is having any kind of a right, any kind of a asset, any kind of a property, any kind of a undertaking, because a charge can be created on the property. The property may be the movable, immovable asset, undertaking, or any interest therein. Point number 2. Whether a charge can be created for a property situated outside India? Yes, the charge can be created irrespective of the location of the property. If it is an Indian company is having a property situated outside India, the charge is created on that property, the charge can be created and registered in India. No doubt, the charge is required to be registered in that country as per the rule of that host country, and then the charge can be registered in India. Question number 3b. Board of a director of Anil Limited has decided not to preserve the books of account and other related records of accounts for a period more than 5 years immediately preceding the relevant financial year of 2016 and 17 due to the shortage of a space, right? Referring to the provision of the Companies Act 2013, examine the validity of the board's decision. If you refer to section 128 of the Companies Act 2013, it suggests that every company is required to maintain the books and other relevant records, voucher, etc. for at least period of 8 years. And here the question is suggesting about destruction or removing after the 5 years. So it is not a good or a valid idea on the part of a board of director. The board can be suggested that if they are having a constraint with regard to the space, they may convert the records into the electronic form and preserve it. They may also ship the records to the other place after following the formality. Question number 3c. RR Limited has decided to make an investment in other companies for rupees 50 lakhs, which is in excess of 60% of the company's paid up capital, free reserve, securities, premium account, etc. Company has 5 directors. 4 directors were present in the board meeting. 3 directors have given their consent, but 1 director abstained from a voting. The decision of a board was noted in the minute of board meeting and decided to make such an investment by passing a board resolution with a majority. Referring to the provision of the Companies Act 2013, examine the validity of the board decisions. Remember, in the case of a section 186, when the proposed investment, guarantee, security, etc. is in excess of 60% of the paid up capital, security premium account and the free reserves, or 100% of the free reserves and security premium account, whichever is more, then the consent should be given by the board in a unanimous manner. Unanimous manner means all the directors present at the board meeting shall give the consent. Here, all the directors present at the board meeting have not given the consent, and therefore the decision of the board may not be considered as a valid. Question 3d. Mr. X is a director in a Greenfield Industries Limited. He is a man of a wide knowledge of commercial matters. The company has not fixed the final financial statement with the Registrar of Companies for 3 years ended 31st March 2014, 31st March 2015, 31st March 2016. However, it has filed the annual return for those years in compliance of the provision of the Companies Act 2013. Considering the Mr. X huge experience, Redfield Industries Limited wants to induct him as a director on the board. Referring to the provision of the Companies Act 2013, examine the validity of such a proposition or such an appointment. Remember, when any company do not file the financial statement or annual return for a continuous period of 3 years, section 164 subclause 2 will be attracted, and as a result of which also all the directors who happen to be the directors on the board of that company will be disqualified to be reappointed in that company, and they are also ineligible to be appointed as a director in any other company. The Greenfield Limited has not filed the financial statement for 3 years, and therefore the Redfield Limited cannot appoint the Mr. X as a director. He has become a disqualified. So the question number 3 was having a lot of variety of subject matter in terms of an application, in my view, and the student should be ready in a future as well to deal or to tackle with this kind of a practical question, because nowadays you will find a practical based question paper. Moving the alternative question of a 3 small a, we are having a 3 capital A, 1, 2, 3, 4. A newly incorporated Avai Limited has not mentioned the name of a first directors of a company in the article. Referring the provision of the Companies Act 2013, advise the board of directors regarding the appointment of first directors of the company. What would be your answer in case the company is a one-person company? Also state whether the provision of the act are applicable to the private limited company. Refer a question number or a para number 10 of a chapter number 14, institution of a director. Usually the name of the first directors are mentioned in the article. If the article do not contain or does not contain the name of the first director, then the natural subscriber to the memorandum will be the first director of the company. Number 2, the board of directors of AVB Limited wants to declare a dividend of rupees 15 lakhs out of the capital profit for the year ended 31st March 2017 without making a provision for a depreciation. Referring to the provision of the Companies Act 2013, you being the secretary of the company advise the board whether it can go ahead with the proposal. See, there are the 2 points. One is they would like to declare a dividend out of a capital. Second, they would like to declare a dividend without providing a depreciation. Company can declare the dividend out of a capital if the article of a company authorize, if there is a actual realization of the capital profit, the valuation has been carried out of entire the asset and liability, etc. So there is nothing wrong if the company declare the dividend out of a capital. But the company cannot declare the dividend without providing the depreciation. So it was a good question, tricky question in my opinion. 3A, 3 capital A, number 3. Chargi Biotech Private Limited is a 2 years old company. The board of directors of the company wants to contribute the 2.8% of the average net profit of the last years to the Prime Minister Relief Fund. Referring to the provision of the Companies Act, advise the board. Remember, you may provide any amount of a donation or a contribution to the Prime Minister Relief Fund, right, or a National Defence Fund. You may refer the paragraph number 23 of chapter number 16 of my book, 3rd edition, A Company Law, published by the Taxman. Question number 3A4. CIF Techno System Private Limited is proposed to be incorporated in a Bhubaneswar, Orissa under the Companies Act 2013. The company will be the holding company of a CIF Holding Private Limited already incorporated in Brazil under the Company Law of Brazil. The company in Brazil follows the financial year from 1st January to 31st December of a calendar year. Referring to the provision of the Companies Act 2013, state whether the financial year of a CIF Technosystem can also be a 1st January to 31st December. In order to make it easier to prepare the consolidated financial statement, yes, it is possible. You may refer the paragraph number 4, chapter number 21 of my book. It provide the procedure and it provide when it is allowed. Question number 4A. KPS India Producer Limited having an average annual turnover exceeding rupees 6 crore in each of the 3 consecutive financial years. The company has to appoint a company secretary. Advise the company by referring to the provision of the Companies Act 1956 as applicable to the producer company relating to such an appointment. As for the provision of a producer company, if any producer company is having a net profit of 5 crores or more in each of the last 3 years, the producer company is compulsorily required to appoint the company secretary. Question number 4B. Shaky Commodities Private Limited could not hold its 10th annual general meeting for the year 2016 by the 30th September 2016. The company sought an extension of a time for holding the AGM from the register of companies but failed to hold the meeting within the extended time too. Instead, it held the meeting on a 31st March 2017 quite late and passed a resolution thereat. Certain shareholders have challenged the validity of these resolutions, referring to the provision of the Companies Act, examine whether the contention of the shareholders shall be tenable or not. Remember, company is required to convey the AGM within a stipulated time or within an extended time. But if the company cannot convey the AGM within a stipulated time or within an extended time, then the meeting which has been held with a delay will not be regarded as an invalid meeting. In the judgment of a Gardner versus Iredell, the Chancellery Division of UK has held that once a meeting period is over, statutory period is over, and thereafter the meeting is held, the meeting is a valid. The resolution passed thereat will be the valid, because you cannot travel back a time and convey the meeting. So the defaulting director will be liable for the purpose of penalty. A meeting will be valid. Question number 4C. From the following information in respect of two companies, XYZ Limited and CBA Private Limited, compute the amount the companies are required to spend on account of the CSR. Same example I have given in my book. I have given the 5 different examples in my book. Here, out of the 5 examples, the 2 different category of companies are taken. So you may refer the paragraph number 16 of chapter number 16 of my book, right? And you will get an answer as well as a clarity on the part of a concept. Question 4D. During the financial year 2016-17, the Board of Directors of CARE Automation Services Limited has issued shares to the employee under the Employee Stock Option Scheme. Ms. Excellent has recently joined the board of a company and asked you, the secretary of the company, as to what details are to be disclosed in a board report for the year ending 31st March 2017. In this regard, advise here. See, the question has been asked for 4 marks, and I am very much sure a lot of students interact with me that they never expected this kind of a question about writing a details on a particular matter of a board of director. Remember, in my book, already in a 2nd edition, in a 1st edition, and also in a recent edition, the 3rd edition, I have included every minute detail. And I have also included that what matters should be published when the company has issued the shares under the stock option. You may refer the paragraph number 10 of chapter number 6 for that. Moving to question number 5 is 5A. Radhika Textile Limited has utilized the security premium during the financial year 16-17 as follow. Rupees 13 lakhs against the expenses of foreign travelling of a director. Remember, my dear friends, as per section 52, the security premium account can be utilized only for a specific purposes. If the company do not utilize the security premium account amount for specific purposes or utilize for some other purposes, then it will amount as a capital reduction. You cannot utilize this amount to pay the expenses of a director. Point number 2, rupees 5 lakhs for writing off the balance of a preliminary expenses of a company. Yes, as per section 52, the security premium account amount can be utilized to write off the preliminary expenses which has not been set off. Question number 5B. The board of directors of Day-Night Prakashini Limited wants to shift the register office, and for that you have been asked to draft a notice of a EGM. Now, it is not a good idea if I speak the notice of a EGM, right? You may refer it from my book, third edition, a company law published by the taxman, contain the sole paper of June 2017. So I'm moving to question number 6. A. Mr. Sunil Goyal, a director of XYZ Limited, wants to go on a foreign trip. He wants to assign his office to the vice president of the company. Mr. Sunil Goyal, seek your advice whether he can do so. Referring to the provision of a Companies Act 2013, advise him in the matter. Remember, if any person is going out of a country, in his place the alternate director can be appointed if the other conditions are complied with. But it does not allow any authority or a power to the director who himself is going out to appoint or to assign somebody else as a director, because as per section 166, the assignment of the office by the director is invalid, right? Moving question number 6B. Mrs. Beautiful, aged of 40 years, is a MD of a beauty care product limited. She has received the contribution to the superannuation fund and leave encashment during her tenure with the company during the financial year ending 31st March 2017. The manager accounts of the company is not very confident if these perquisites are to be included in the computation of a ceiling of the remuneration specified under the Companies Act 2013. So referring the provision of the Act, advise the manager accounts. Now this question demands the minute understanding of the subject matter, which amount, which perquisite, which benefits are included in a managerial remuneration and which benefits are not included in a managerial remuneration. For a detail, you may refer the paragraph number 8 of chapter number 17 of my book. But remember, would like to clarify here that the superannuation fund and leave encashment, the gratuity benefit of a 15 days salary for each completed year of services are not included in a managerial remuneration. Moving to question number 6C. Mr. Solid, a young professional of 29 years, has stayed in India in 150 days in the previous financial years. He does not hold any shares in a Happy Retails Limited, which is a listed company. Small shareholders have decided among themselves that he is proposed to be appointed as a small shareholder director who shall not be liable to retire by rotation, and his tenure shall be for 5 years from the date of joining the office of a director. So many points are given. It is a very interesting here. Examining the provision of a Companies Act 2013, state whether Mr. Solid can be appointed as a small shareholder director. For a complete theory, you may refer the paragraph number 6 of chapter number 14, institution of a director. But the point is that any person can be appointed as a small shareholder director. Only thing is that he cannot be appointed for a period more than 3 years. Small shareholder director cannot be appointed for a period more than 3 years. The rest, everything is in order, or the proposal is in order. Question number 6D. As a practicing company secretary, advise your client company regarding the matters relating to the issue of a shares with a differential right, DVR share, to be included in a board of directors report. Remember again, here I have found the question which is asking what should be written in a board report. Again, I would like to state that I have included a very minute details in my book earlier and as well as into my next edition. You may refer the paragraph number 6 of chapter number 6 as to what matters are required to be included in the DVR shares in a board report. Now with this I would like to conclude with a one more suggestion, or with a point or hints, that nowadays you will find a paper in a CS executive which are based upon the application. Earlier it used to ask, or it is having the theory question or the practical question being repeatedly asked. Nowadays it is not so. So you should refer the material of an institute at least once. You should also refer the good reference book and try to learn the subject in a thorough manner. I have seen many students who are just going through the last 10 years paper. It was right 2 years back, somebody referring the 5 or 10 years paper, easily clearing the exam, but nowadays it is not possible. So do not take a chance with your attempt and with your career. Thank you very much.